Good afternoon and an official welcome to our 9th Annual MLK Convocation. My name is Mitch Zamoff. I'm a professor in law and alternative dispute resolution and the Assistant Dean of Experiential Education at the law school. Interim Dean Bill McGovern wanted very much to be here today to introduce this important program, but he got quite sick last night and tested positive for COVID, so he can't be here today. But you know what? I'm doing this for all the understudies, all the second string athletes, and all the second chair lawyers who practiced and rehearsed and prepared for their moment. I speak for them today. So at Minnesota Law, we host this event each year to convene our community, students, faculty, staff, and friends, to reflect on the work of Dr. King and connect the challenges of today to his transformative work. I'd like to thank you all for joining us today to reflect on Dr. King's legacy. Thank you also to our Assistant Dean of Diversity, Equity, and Inclusion, Ra'Shya Ghee, and the Racial Equity and Justice Committee for sponsoring this important annual event. Here at Minnesota Law, we know that lawyers play a critical role in defining, protecting, and expanding reproductive freedoms for people both in the United States and abroad. We also know that with this privilege and power comes an imperative to educate ourselves on the history and lessons of the movements for reproductive justice and to listen to those most impacted by the laws and policies of today. Today, we're honored to have two experts to inspire and guide us. Professor Michele Goodwin is the Linda D. and Timothy J. O'Neill Professor of Constitutional Law and Global Health Policy and the co-faculty director of the O'Neill Institute for National and Global Health at Georgetown Law. She is an acclaimed bioethicist, constitutional law scholar, and prolific author, as well as a leader in the health law field. Professor Goodwin is the author and/or editor of 6 books, including Policing the Womb, Invisible Women, and the Criminalization of Motherhood. Dr. Goodwin is the 2023 recipient of the California Women's Law Center Pursuit of Justice Award. She is an elected member of the American Law Institute, as well as an elected fellow of the American Bar Foundation and the Hastings Center. I need a drink of water in between listing Professor Goodwin's accomplishments, but I don't have water, so I'm just going to reflect and continue. She was formerly a chancellor's professor at the University of California, Irvine, where she was founding director of the Center for Biotechnology and Global Health Policy. She was also the Abraham Panansky Visiting Professor of Law at Harvard Law School, senior lecturer at Harvard Medical School, and undoubtedly her most important credential on this day, the Everett Fraser Professor of Law at the University of Minnesota Law School until her departure in 2013. Professor Goodwin, we are thrilled to welcome you back to Minnesota Law today, and thank you so much for joining us. Professor Goodwin will address the topic, Dr. King and the Long Arc Toward Reproductive Freedom and Justice, moderated by Dean Ghee. I'd like to say a few words about my friend and colleague, Dean Ghee. She returned to Minnesota Law as our first Assistant Dean of DEI after graduating from this law school in 2013. She has a BA and MBA from the University of Toledo and practiced criminal defense and family law in Ohio. As a consultant, Dean Ghee facilitated cross-racial coaching, providing commentary on racial tensions to news outlets, and helped organizations center racial equity and operationalized anti-racist frameworks. She's also served as an adjunct law professor, including here at Minnesota Law. Thank you to Dean Ghee for her role in organizing the program and for leading the conversation today. Before we begin, I just want to make 3 quick notes. First, today's event is being recorded, and the link to the recording will be shared via email with all registrants following the event. Second, there will be time at the end of the discussion for some question and answer that will be moderated by Dean Ghee. And third, there will be food waiting for you at the end of the presentation. We're going to wrap up a few minutes early so you have time to get your lunch on the way out. With that, I'd like to ask all of us to extend a warm welcome to Professor Goodwin and Dean Ghee.
have to make an administrative note in the future that my bio should never be read after Professor Goodwin's. I should get a soft introduction and we should move along. I don't know if I've ever told you this, but my time here as a law student was profoundly impacted by you. Your encouragement and affirmation for me as a first-gen student who did not come from college-educated parents helped me believe that I belonged here. And two of the nuggets you gave me, I still carry with me every day. So you introduced me to hot yoga. I still go. To the same place, in fact. And you told me that I needed to make sure that I read every day just for curiosity, not for any professional or academic obligations, just for watering, I think is what you called it, that it would be a form of self-nurturing. And it is something that I carry with me every day. I still do it. It has led me to the most incredible and enlightening experiences that I do that. So I really appreciate that I got that from you while I was here.
Thank you so much. I'm so proud of you.
I appreciate that. Okay, so as a departure point for our discussion today, we are using Dr. King's acceptance speech for an award that he got from Planned Parenthood, where in this speech he marries the struggles for racial justice and racial equality to our struggle for reproductive freedom. Why do you think it was important for him to do that, to articulate that relationship? And what do you think we can draw from his example in this moment?
Well, thank you so much for having me, I should say, first of all. It is absolutely wonderful to be here in your presence and that of my colleagues and friends for life. Thank you all. Really, it's an honor. In thinking about Dr. King and in this moment and space that we're in where reproductive health, rights, and justice is something that we're reading about every day, questions of it. For Dr. King, he recognized in 1966, when he writes this speech that is delivered by his wife, Coretta Scott King, to Planned Parenthood upon receiving an award from Planned Parenthood, what he recognizes is that the very first journeys of lawmaking in this country involved questions of reproduction. And those questions of reproduction were very specifically questions that related to Black women and girls and their bodies. I mean, he recognized what was difficult then to grapple with, and probably still very difficult for many people to grapple with today. For example, when we think about matrilineity, what became ensconced in American law, that you do not take on the status of your father, you take on the status of your mother. Very purposeful and very intentional. If you look at the records left behind by Thomas Jefferson, he wrote to fellow politicians, fellow planters, that it was overstated to think about your plantation as being a space for men and their work. He said that he liked and preferred to stock his plantation with girls and with women because they were turning a profit every year or two. Now, he wasn't talking about, oh, Black women just pick cotton better than Black men. He wasn't talking about Black girls are better at tobacco than Black men are. He was very specifically talking about the forced coercive labor upon their bodies that was sexual. This embeddedness of sexual assault and rape that was just a part of the language of colonialism, the language of the antebellum period and American slavery, made visible in ways that were hard to ignore. You look at the advertisements of that period of time, there's no holding it back. And such as not abolitionists sort of claiming something of the 1700s and 1800s that they're making it up. If you read the advertisements coming out of South Carolina, North Carolina, Mississippi, all the way up to Connecticut and New York, where planters are advertising all over. And then you wonder, well, what is a breeding wench? How do you, at 12, what in the world does that mean? Or the advertisements when you're looking for the breeding wench who's escaped, who's 16 and escaped with her 2-year-old mulatto child. Well, how did she, at 16 years old, be a mother of someone who's 2 years old? And then the racialized descriptors tell us so much. So I think that in part what Dr. King was doing was level setting. And level setting in a way that came across the arc of history, because even in 1966, what he was showing is that that past tethered to the present. And most specifically, in that speech, he references how it is untenable having what was perhaps perceived as necessary in an agrarian economy where you might have 10 kids. Where that could happen in upstate Minnesota, Wisconsin, et cetera, you're farming, you have many kids. But he was connecting this to the Great Black Migration northward. And that too is so deeply loaded, right? There could be volumes written about that speech. Why was it that African Americans were migrating in the 40s and 50s and 60s northward? And if we unpack that, well, then that's also deeply chilling as well. And when you consider, you take a Fannie Lou Hamer, for example, as an example, although she stayed south, but when your voting rights have been denied, when there are laws that say you may not walk in the park, when there are laws that say you may not swim in the swimming pool, when there are laws that are so absurdist that you question what were people thinking when they wrote it, that you can't play checkers, you can't play chess, you can't play billiards, and you can't go bowling. And that it's illegal if you are in a car with a white person, and illegal for a white person to come into your neighborhood, like all so absurdist. And so Dr. King was also referencing that Great Black Migration that would pull people from the South north, and saying that what was reasonable, perhaps, having 10 kids in that dynamic because you're farming and you're sharecropping, how that could not be sustained in a one-bedroom tenement in Chicago. I mean, he's specifically saying that that is cruel. He used the terminology of it's cruel, it is unsustainable. And a way of addressing that was family planning, and that women deserve the ability to be able to decide what was going to be the scale and scope of their family so that they could have dignity. And how undignified it would be then if you can't plan and you've got 10 kids crushed into a segregated community in a one-bedroom tenement.
Thank you so much. And I'm so appreciative that you contextualized it historically. Also, my grandfather has told me stories about being arrested. He was stationed in Mississippi. He told me stories about being arrested because he was with a white companion and it was illegal. It was an anti-companionship law or something.
Oh, absolutely. There's so many of them. Just as a moment to shout out to Pauli Murray, which I think is so important. So for those who don't know Pauli Murray was a lawyer, an intellectual. Pauli Murray preceded Ruth Bader Ginsburg, and she was also a theologian.
Playwright.
And a playwright. There's and a poet.
Poet, that's right.
So Pauli Murray preceded Ruth Bader Ginsburg at the ACLU, preceded her in graduating first from her class. She laid the groundwork that Ruth Bader Ginsburg would then pick up at the ACLU, both in terms of the strategy to fight sex discrimination. The 1945 is a law review article published in the California Law Review about combating sex discrimination in the workplace. It's written by Pauli Murray. When Pauli Murray is a law student at Howard, because with racial discrimination, her options in terms of where she could go to law school were very limited. She could go to Howard because Howard would not discriminate against her based on race. She found that there were other forms of discrimination, such as being a woman in the first year class and her professors refusing to call on her, but she was first in her class after that first year. And so by the second year, they began paying attention to her. She is credited with writing papers while she was in law school that her professors then used in Brown v. Board of Education. So for a twofer, both in terms of sex discrimination and also racial discrimination, Pauli Murray was doing that work while she was in law school. She later wrote, amongst the books that she wrote, was one that is on race laws in America. And the purpose of the book was just to identify that we would have a record of these race laws. The book is nearly 800 pages, single space, and it just identifies all of these laws and by state. And that is where you see this absurdity, where people in legislatures were just kicking back and just making up these absurdist laws, including what you're referencing, standing next to a white person or a white person being your companion as you're standing on a corner as being illegal. And what all of that texture, which I think is really important for us to think about, because we kind of begin and end with Rosa Parks. One day, Rosa Parks didn't want to give up her seat. And then there she is in that beautiful bouffant, holding up the sign, and that's it. Not understanding that Rosa Parks was a civil rights activist, and that before that brand of her activism, she was deeply concerned and worked on behalf of matters of Black women and rape and sexual assault, and so much more. I mean, I could go on and on in this, but it's important that we know about Pauli Murray and give it up to her. And Ruth Bader Ginsburg did, not shortly before her death, but in a few years before her death, explained that without Pauli Murray, she would not have been able to be Ruth Bader Ginsburg.
I was going to let you go on and on. I was going to throw these questions behind me and I was just going to let you go. Okay. You mentioned before how Dr. King's work invokes this kind of colonial and antebellum history, right? Even now, we've seen people, I know that you're familiar with the woman in Ohio who they attempted, Brittany
Yes.
Watts, who they were attempting to pursue criminal charges for miscarrying. And I saw someone characterize that on social media as, they said something like, punishing women for unsuccessful pregnancies is the legacy of chattel slavery. Mm-hmm. And I've seen people also talk about whether or not there are ways to utilize the 13th Amendment to argue that there is specific protections for women's reproductive freedoms. One, do you think that a fuller understanding of our racial history could help make those connections clearer? And how would you suggest we promote such a more well-rounded understanding? And then also, do you think these arguments have viability if they get back before the Supreme Court?
So let me start by saying that in the abolition of American slavery, sexual assault and rape was on the minds of the abolitionists. It had been. So Charles Sumner, senator from Massachusetts, so many of you may recall a story about there being a member of Congress who was brutally beaten up as a kind of story of those things happened or that thing did happen without really understanding the context of it. So Charles Sumner, who's a senator from Massachusetts, only days before he was beaten nearly to death, and that is no joke. I mean, he was beaten so severely with a cane by Preston Brooks, who was from South Carolina. And all of this stitches together when we begin to think about it in nuance. So what had Charles Sumner done that would cause this lawmaker from South Carolina to come in with his cane and to find him and to beat him in such a bloody pulp that Charles Sumner would have to take 3 years away for recuperation? Well, what Charles Sumner had done is that Charles Sumner had been talking about these sexual assaults and rapes. And again, keep in mind that newspaper advertisements, newspapers which used to come out twice a day, but even once a day, what are people seeing? They are seeing what people are now, they're bold. They're absolutely bold. You can't make these advertisements up. The advertisements on who you're going to sell, who you're trying to find, the breeding wenches, the description of their children, you can't make this up. Everybody is seeing it because these advertisements are all across the country. The Connecticut Current did a piece about a decade ago, raising the question, how have we been complicit? Were we complicit in the thousands and thousands of advertisements? These kind of advertisements of the breeding wenches who were 10 and 12 and so forth. Were we complicit in somehow making money off of this? There were many systems of making money off of this. So when we think about the 13th Amendment, Charles Sumner being beaten to a near pulp after giving a robust speech where rape is in the title of the speech. And he is specifically referencing what is happening in the South. There are abolitionists that are traveling to the South, and none of this is being hidden. It is not being hidden at all, where you have little girls who are committing suicide. We don't talk about it. Jumping off the tops of barns and whatnot. Not a pause to understand what Dr. King understood. And sometimes I ask audiences to just pause and think about, what story does a mother tell her child the night before the slave auction? It's not something that we're pressed to do in our society at all. But these auctions took place all over the place. The largest slave auction house space was in South Carolina. The second was right off of Wall Street. And we don't do it because we don't think about, well, what it means to be enslaved, what it means when people are kidnapped on their way to visiting a mother, a grandmother, a friend. That people had lives before they're rounded up in Ghana and other places. There were things that they were doing, people that they loved, relationships. It's a day. It's as if anybody came in here at any point of the day and took us away. We have relationships. We have lives, we have passions, we have things that we care about. And then on this side of the shore, those mothers having to convey a humanity to their child, although the law makes nothing human in them. The law says that they are property, local law, and then the federal law gets complicit in it in 1850 with the Second Fugitive Slave Act, where the federal law gets complicit. It denies these individuals the ability to speak and defend themselves when they are captured. It perniciously grants and perversely grants more money to the magistrate if they decide that, yes, you were a runaway versus you've been living here in Philadelphia all this time. Right? All of that is embedded then in the question about how do people then try to express humanity to their kids, that though you will be sold tomorrow, though I will be sold tomorrow, you're not a cat, dog, mouse, something in the field, though law says you're that. You have humanity, you have capacity. Never lose this sense that you are a human being with value and integrity, no matter how long it will be until law somehow recognizes that in you. There had to be some story that these mothers were telling their children. We fail ourselves in our own humanity when we think that they didn't. And something about being bigger than this moment, being bigger than the people who will put you in shackles and chains and advertise to sell you away. Charles Sumner got that. And so did many other abolitionists. And one of the cruelties amongst many of the cruelties is that the abolitionists are not remembered. So we may remember a Frederick Douglass, a Sojourner Truth, and they should be remembered when Sojourner Truth says, after the fugitive slave laws, ain't I a woman? And what she's talking about is not just what people cling to as chivalry, right? You know, no one opens up a carriage door for her. That's the part that's been remembered. But before that, she says, and I bore 10 children and saw nearly each one snatched from my arms, and nobody heard my cry but God. Ain't I a woman? And so when Charles Sumner and others who are white, who risked being lynched and were lynched, their printing presses blown up, and so much more, began their fight towards the 13th Amendment, they were specifically referencing these matters of sex and forced pregnancy and rape. So that if we understand the 13th Amendment, when it abolishes slavery and involuntary servitude, there is something more in the texture of that that is very explicit that they are referencing. Involuntary servitude, because they realize that there is a sexual involuntary servitude that has an economic interest, a political interest, and so much more. And I do believe that recognizing that now gives added legal analysis and response to the present moment that we're in.
Do you envision the court being receptive?
Well, of course, that depends upon which courts that we're talking about. The Supreme Court, we are approaching the second-year anniversary of the Dobbs decision, where the United States Supreme Court has claimed that its methodology, the majority, that its methodology is originalism, which is interesting and ironic because they're different. You think about a case like Bostock, where the Supreme Court said that Title VII applies to LGBTQ individuals, right? I think it's a good decision. I think it was a right decision. But there were people who claimed to be originalist who are in the majority, concurrence, and dissent, right? So what does originalism mean within all of that? And one could say that the court is engaged in selective originalism, especially in the Dobbs decision, because the Supreme Court makes no reference whatsoever to this history. Keep in mind that it's not like the 13th Amendment comes a year after the 12th Amendment, and a year before that there was an 11th Amendment. This is more than 60 years apart. This is a reconstructed Constitution. It is a robustly, deeply reconstructed Constitution with federal legislation that comes after it and a 14th Amendment. It is reconstruction. It is really a new Constitution, and a new Constitution that completely resorts, people in society, beginning with this abolition of slavery and involuntary servitude and then going on to a 14th Amendment. There is a kind of ahistoricism then that one sees in the originalism that the majority is clinging to. It's something that Justice Ketanji Brown Jackson has referenced. How do we understand a 14th Amendment when we strip it from its racial qualities? Right? I mean, this is what it was. We lost more people in the battle of the Civil War than any time ever in the U.S. history. All right, so our court, the Supreme Court, maybe not, but there are judges and who are asking for briefings on the 13th Amendment, and it's a muscle that hasn't been worked by lawyers, and that's a point too, is sort of understand the broader reach of how we use the Constitution. Years ago, people critiqued Griswold, 1965, striking down constitutional barriers to couples being able to have contraception. And the critique was that Justice Douglas went too far. It was just like tossing everything like a big salad. But I think if people, sort of step back and think about that salad, there was a lot that was actually quite relevant in terms of what Justice Douglas was doing, right? And that as we think about our right to be able to utilize contraception, or at least for that case with couples, it does connect to the First Amendment. It does connect to the Fourth. It connects to the 14th. It connects to the Ninth Amendment, all of these things. And so I think that now may be the time where we recalibrate our thinking about how the Constitution should relate to the concerns of women and what that might look like.
How am I doing on time? Because we have more questions, but I want to make sure that I save enough time. I'm good. Okay, that's a thumbs up. Awesome. Fantastic. Thank you. Okay, do you have any recommendations for concrete steps that those of us who are interested in the kind of intersectional advocacy and solidarity between these movements, the movements for reproductive freedom, the movement for racial justice and racial equity, what kinds of steps can we take to kind of ensure that synergy is utilized and optimized for advancing these goals?
Well, I think one of the first things, and this may not seem like a concrete strategy, but I believe it is, and that is what we must read. If we really care, we have to become students of this history and really understand it. Otherwise, there are ways in which it doesn't fully settle in our minds and our hearts. As psychologists say, you have to hear something 7 times before it really resonates, before you really get it, right? And there is a way in which we really must understand these histories in deeper ways that are part of our soul, mind, thinking. And then beyond that, the intersectional question that you asked is that these matters stitch together. You can't be concerned about reproductive rights without being concerned about voting rights. And in the Dobbs decision, Justice Alito said that, well, for those who would be concerned about access to abortion in their states, then vote. Take these matters to your legislature. Now, what's interesting about that is that if you look at this intergenerational history of voter suppression in places like Mississippi, which brought us the Dobbs decision, it's worth actually noting one of the best decisions that has been in this space. And so I would say vote, educate people how to vote, protect the vote, be election watchers, be involved in that space. And we know that this has been a time in which people who have worked to support the credibility of our elections have been attacked. And that doesn't matter. And most of these are women, regardless of what political party. But it was Judge Carlton Reeves who wrote the lower court order before Dobbs made its way to the United States Supreme Court, because there was a stay, an injunction against the law. Mississippi had passed at the time, Roe was still the law of the land, Planned Parenthood v. Casey, and Mississippi was part of a group of states that were planning basically trigger laws, right? Roe falls, these laws come into place. And it was a 15-week abortion ban with no exceptions for rape or incest. And it's also worth noting that when the oral arguments in the Dobbs case, when it went before the Supreme Court, not one question that related to those matters, which says a lot. And the Supreme Court spent no time writing about maternal mortality, maternal morbidity. I suppose I should just level set for one quick moment, then get to Judge Reeves, which is that in 2016, in a case Whole Women's Health v. Hellerstedt, it was a 5-3 decision. Justice Scalia had passed away, so it might have been 5-4. But in that case, the court struck down 2 Texas laws that the court found were unconstitutional in their encroachment on abortion rights. That case is important because of the lower court record, which made its way into Justice Breyer's written opinion. And he pointed out that a woman is 14 times more likely to die carrying a pregnancy to term than by having an abortion. And there were myriad other kinds of healthcare matters that Texas didn't regulate, that you could have outpatient, no waiting periods, anything like that, where the risks of death were far more high than by having an abortion. And I think that that's important, along with the next fact that I think should just guide how we understand these matters. And that is, the US is the deadliest place of all industrialized nations to be pregnant. We rank around 55th in the world in terms of maternal mortality. And then when we pull out the racial factors there, for Black women, they're 3.5 times more likely to die carrying a pregnancy to term in the United States than by having abortion. That means Black women who want to be childbearing or find themselves in that position are 3.5 times nationwide to die than their white counterpart. But that doesn't account for the counties and the various cities where they may be 5 times, 10 times, 17 times more likely to die by carrying that pregnancy to term than by having an abortion. Or that in the state of Mississippi, 80% of the cardiac deaths during pregnancy happen to Black women, who are not 80% of the female population or populations with uteruses in that state. So just in level setting. So back to Judge Carlton Reeves, and then I'll be quiet so we can go on with the questions and any from the audience. But that opinion, I remember the day that I read it, because it was a highly unusual opinion within this space because of its footnotes. And I like to read footnotes like they're an essay or an article. And in his footnotes, he referenced Fannie Lou Hamer. He was calling out Mississippi. Mississippi's argument had been that its abortion bans were about protecting the health and safety of women. And again, if you don't read and you don't know, you could think that an abortion was the most ridiculous decision a woman might make, that it would be dangerous for her. Why would you want to do this dangerous thing? Because of how the media has covered this. And so Judge Reeves, in his footnotes, begins to attack this. Mississippi, show me where you have ever cared about the health and safety of women, about the liberty of women in your state. Show me how you've ever cared about women serving on juries, being able to vote, being able to have check accounts in their names, being able to have your own credit card. Tell me about this in light of the Mississippi appendectomy, which was not an appendectomy at all, but the coercive sterilization of Black women in that state, including with Fannie Lou Hamer. Tell me about your commitment to women in the state when black women were beaten as they tried to go to vote, which then says a lot about Dobbs years later, right? And so Judge Reeves, that decision, so unusual because it really took on looking at the status of women, looking at the status of black women in the face of attacks on reproductive health care.
I appreciate that. I think that that is helpful for us to think about becoming students of this history, learning to contextualize our arguments appropriately so that we can paint the full picture when we advocate on behalf of the causes we care about. Okay. I can take some questions then now. How about we, you know what though? One more, I'm sorry. When we
I'll
originally—
be quick on this one, I promise.
When we originally planned this and sketched this out, it was before the Alabama Supreme Court decision came down.
That's right.
So I had to email you again and say, I didn't expect this much change in the last 3 weeks, but here we are again, right? It feels to me as though things are happening very rapidly. I saw you on MSNBC and ABC News talking about this, and you referenced an even earlier case in Alabama where they used a child endangerment law around methamphetamines to weaponize against women as kind of the precedent for the Alabama Supreme Court decision. Is it moving as fast as it feels? Are there changes everywhere?
Well, let me just say, I was teaching here at the University of Minnesota when I was going and taking trips down to Alabama, interviewing prosecutors and waving a flag saying, here's what's coming, here's what's about to happen, including interviewing the current state's attorney general when he was a local prosecutor and was part of a movement to be engaged with physicians and nurses as they were documenting patients who were coming in expressing their social histories, which would include having taken a drug during pregnancy and whatnot. And he was part of a movement amongst prosecutors to then prosecute these women. And I wrote about him. He's actually written about in the book Policing the Womb and other articles. I mean, it was happening and it was going to happen. And I think it was ABC News or NBC, one of them pulled up an article that I wrote while here, possibly maybe got published after I was at UCI, but it was raising this question because of what was already taking place. So I guess I'll end that question before we go to others on this note, particularly for students, and that is, do excellent work, follow, dig, and it may be later that people recognize the value of what it is that you have done. But pursue the questions, answer the questions, even if it is that right now people are not seeing what it is that you have been discovering.
It looks like we already have some questions. Yes, there's so many. Professor Hasday.
Not exactly a question, but I think it would be interesting to hear your comments on the anti-abortion movement has taken up like the racial eugenics argument, especially Justice Thomas. So just an opportunity for you to discuss.
Well, and it says a lot about a Supreme Court that had such limited racial diversity over the arc of its history. And the first time in the Supreme Court history where there are two black justices sitting at the same time. So Justice Thomas has asserted that abortion is connected to eugenics, and abortion and eugenics are connected to the suppression of the African American community, without any kind of context to history and the sort of arc of history. And this has made its way into Supreme Court decisions, at least in the footnotes, and then above the line with Justice Thomas. What's so searing about that, of course, is that when the United States Supreme Court itself actually takes up eugenics and sanctions it in 1927 in a case called Buck v. Bell, it's not a black child, it's not a black woman, it is actually a 16-year-old white girl, Carrie Buck, who, like other white Virginia poor girls, were being rounded up to a place called the Virginia Colony and being coercively sterilized as part of the deeper growing eugenics movement in the United States that was targeting poor white people who weren't the right kind of white people. At states fairs across the country, there were fitter family contests that were not about black people and not about indigenous people, but where white people were lining up for the purpose of being able to prove and show that they had the fitter family, that their kid had the bluest eye, the blondest hair, and then get some sort of an award or acknowledgement. Fast forward, not much longer after 1927 comes the Third Reich, almost verbatim taking on that eugenics law and implementing it into its Nazi policies. It's ironic then that years later we have Justice Jackson from the United States Supreme Court being the lead prosecutor at Nuremberg in the doctor's trial. And many people don't know that there was a doctor's trial separate from the other trials at Nuremberg. And in the doctor's trial, the affirmative defense put forward by doctors who had been engaged in eugenics and much more was, how dare you? We picked up on what you did. And in fact, they did. They came and they studied eugenics and how it was being carried out in the United States, and also Jim Crow in the United States. And so I thank you for the question, and we can unpack it even further. Later on, black women become implicated in these coercive sterilizations. Note 50s and 60s as black women are demanding inclusion in social welfare programs. And the response is, you're having too many kids and your childbearing needs to be limited. Professor Wolf. It's always great to see you. We see a lot of each other on Zoom. It's a great way to put it, this moment of truth. And one could see it on a spectrum. On one hand, there are medical professionals, doctors, nurses, and others in that satellite who've been what Paul Butler once shared with me years ago after hearing me talk about this. He says, Michele, they're snitching on their patients, right? They're black and brown patients, they're snitching. And that's Brittany Watts' case. This is how police come to her home, bust her toilet. They destroy her toilet, looking through fecal remains and her fetal tissue, proof of her miscarriage. But on the other hand, and that is real, and that also raises ethical questions, moral questions. How are lawyers advising them? Are they seeking advice from lawyers? What's happening at hospitals and general counsel? What's taking shape? And a lot of muscle that's not being worked in terms of thinking through strategies to protect them and also to guide them. And then on the other end, the people that we work with, Susan, and the heartbreak, I don't know if you didn't weep or that I know I have felt it with friends who are OBGYNs and others. As Susan knows well, I have friends who refuse to have their photos taken or their images have to be blacked out after video recordings like this because they fear someone might come to their home and try to harm them or their children. That is a reality. In the period since Roe v. Wade, there have been more than 50 bombings of clinics. There have been people who've been shot at their church, doctors who provide reproductive health care, killed at church, killed in their homes, homes set ablaze, all of this, which doesn't really get covered. And then at the same time, in the backdrop of this, Texas as an example, where Kate Cox had to flee the state in order to be able to live, essentially. Yes. In Texas, you could lose your license to practice, you could be fined up to $100, and sentenced up to 99 years of incarceration for violating the state's law, which bans abortion after 6 weeks of pregnancy. And the state does have an exception, but the exception is so very narrow, and that state Supreme Court said that a woman like Kate Cox, where a district court said that, yes, she should be able to terminate this pregnancy because it's non-viable, it threatens her future fertility, and it threatens her life. And yet she couldn't meet the qualification of the exception. And were her doctors to have intervened, that's the kind of punishment that they very likely might have faced because the state's attorney general warned that if anyone intervened, any physician intervened, after that district court opinion, he was going to go after them. So it is a scary time. It's a horrific time. It's a horrific time for people who came into the profession of healthcare to heal people, and now being disrupted from being able to do that. And you are absolutely right that we must think about the role of lawyers and how do we protect, how do we shield, how do we advise in those spaces.
Yana.
This microphone's a little bit better.
Just to add to what you just said, I saw something that said Kate Cox had also, she was concerned that the new Alabama law, if Texas adopted it, would also impact her because apparently she preserved eggs, hoping to at one time, later on. And so there's this also withdrawal, there's this drain of healthcare professionals from these places that need them most.
And can I say this really quickly? One of the concerns in a space of hyper-policing, which I think we can't deny, right? So you have to say when police come to folks' homes after a miscarriage, which for millennia, women have experienced miscarriages, right? It happens, and it happens at home. It can happen in a car, it can happen wherever, but it can happen and does as a person is trying to relieve herself. That happens. But if you look as an example of that, and I think we shouldn't just see it as isolated, but to come into someone's home, to go in their bathroom, break open their toilet and whatnot, I mean, that's policing. That's hyper surveillance, that's policing. Now to think about Alabama, which was already involved in surveillance and policing, there have been more than 500 poor white women who've been caught up in the state's child endangerment law. A law that was not intended to focus on pregnant women, a law that was originally intended for people turning meth labs, turning their homes into meth labs and trying to protect children who were in those homes from being exposed to fire, et cetera, implemented against pregnant women, and now more than 500 women in that state who've taken plea deals associated with information they shared with their doctors, somehow making its way to prosecutors. Okay, that's the backdrop. But now imagine that, and we don't have to imagine it, but a state Supreme Court has said that we see embryos as children. What does that mean for people who have miscarriages when there's the hyper-policing? What did you do to cause this? Imagine a backdrop that has also been exacerbated by misogyny, that gives room to a boyfriend or to a husband. What happened? You were pregnant. What did you do to this pregnancy? And a backdrop where policing and prosecuting takes place. All things that we should be concerned about.
Thank you, Dr. Goodwin, for being here. So you mentioned how voting rights and reproductive rights are connected. And so I feel like I'm a part of a generation that is now becoming doubtful about how effective voting is, especially when the choice often never really feels like a choice, and every election is framed as the election that's going to save democracy in some way. And so whenever we are faced with these choices, often between people who are preceding us 60 to 70 years, what would be your response to how we should navigate that?
I realize that many young people are doubtful about democracy. I realize that our Supreme Court has its lowest favorability or trust ranking since that kind of data has been polled. Voting is so absolutely central to our democracy. The first suffrage movement in this country wasn't about women in voting, it was about poor white men who were barred from being able to vote because they were not property owners. Voting matters so much. It's why Fannie Lou Hamer risked being dragged off of a bus and beaten so that she could vote, such that she could make a difference in terms of who was elected in her state and what that would mean in terms of local elections, school board elections, county commissioner elections, land use. All of that is critically important It does make a difference. Our courts make a difference. If one looks at what we have experienced in recent years in this country, it says a lot about why voting matters. We have seen in recent years Muslim bans. We have seen in recent years children being separated from their parents at the border. We've seen the mass scale deportation of parents, and I've wondered what will their children come home to on a day in which people are being deported. We've seen what democracy, on the other hand, can do assertively, affirmatively. I think even about the relief of student loan debt. That's part of a voting process in a democracy and who's in office at a certain time. In this particular administration, there have now been more women who've been nominated and confirmed to our courts than in any period ever before. And so many of them women of color. And so, from my opinion, democracy matters, voting matters, and it matters in ways that are immediate, but also in ways that are also long-term. And I think that we have to pay attention to, because the votes that we cast today say a lot about what our future will look like. Thank you for that question. I know it's really, really on the minds of so many.
I wish this was all day. I wish we were all going to be here the rest of the day, and this was going to take us into our afternoon, but it's time to go. We've reached the conclusion of our program. I'm so appreciative that you all came out. Please give our astounding guest another round of applause.
You all, thank you so much.
Thank you. It has been an immense pleasure to share space and grow in consciousness with you all. I am forever grateful. Please grab food as you leave, and hopefully we get to do this again soon, right? Like next year. All right, see you guys later.